Well, listening in on that is legal analyst Sinawo Makangela, and he joins us now to take a look at the testimony of the state's fourth witness. Thank you very much for your time this afternoon. Did the defense manage to plant a seed of doubt that this here particular witness is no expert?
Well, we can't tell at this stage. Remember, this is still evidence in chief. He's still hence here to start and tell the court who he is. But I can tell you, this whole case revolves around the issue of identity, if you could say. From the previous witness, the current witness, because it's centered around the issue of whether were they able to identify the accused persons who are before court now. Now, we can tell then, when they weigh the evidence in totality, if the state has been able to prove its case beyond any doubts. Remember, the doubt may not exist. We may see that the evidence of one witness look intact, but if other witnesses do come and contradict that previous witness, then already the state's case does have some doubts. It creates some doubts, because when the accused person takes the witness stand, they have to answer to a case. But now, which case must they answer to? For which evidence, you know?
In fact, you speak of this case centering around identity. Yesterday, we heard from Advocate Mnisi on behalf of accused number 3, whom the state's fourth witness actually pointed out in court, saying the man that he's seeing on the picture that is being beamed in court is the man that he sees as well. And Advocate Mnisi, when the state was taking, or rather presenting its objection, and the judge also contributing there, said this trial is about identification of the so-called intruders on the 26th of October in 2014, and he said it would be unfair to approach the defense in a piecemeal fashion rather. And so when this is concerned, what has been your observation with regards to the judge?
In fact, what I can say, I can commend that there's progress on this matter. Unlike the previous occasion, we know that there's a witness that was under cross-examination for a considerable number of weeks. But now you can see that at least the judge himself is able to direct the proceedings properly, so that there must be progress. However, I think what the counsel for accused number 3 raised was very important, that the court cannot overlook that. That indeed this case revolves around the issue of identity, and they have to deal with it. They have to deal with it in detail. It's not a by-the-way thing. It matters on this particular case, because that is how the guys who are charged today have been identified. All the features, the pigmentation, and all those things are not a by-the-way thing. And for one to say, well, let's quickly move, you can't, because remember, when you argue later, you must argue having put the version of your witness to the version of your client to the witness. So you don't leave that and say, I will deal with an argument. The foundation for the argument must be the evidence, and the evidence must be given to every person who is testifying in court. So for me, I think I do want to take the point of the counsel for accused number 3, that indeed the court must not overlook that aspect. It is very important for this particular case.
In fact, he went on to argue that his client has a different alabaster of a skin complexion, which looks like that of the witness, going as far as saying that the only difference is that the one is Caucasian and the one is African. And so when it comes to the issue of the fourth state witness, this is what the judge said today where credentials are concerned. He just wanted to nitpick a little bit more. Let's take a look, listen.
When you started your career in the South African police, it was in which department? As you were going up throughout your career?
I started in 1982, then I started in the uniform branch.
Right.
From the uniform branch, I went to crime intelligence, then to organized crime, then to the Hawks, and now with cold cases. From the beginning of my career, I was planning to do only 3 years at the unit. And then when I moved to Joburg, I was stuck.
And is it your evidence that you attended refresher courses regularly?
That's correct, and I'm also receiving in-service training on a regular basis.
Right. You are being lectured by persons who apparently are analysts in other divisions.
That's correct, my lord.
Mangiqala ukusebenza ke ngaqala ngo1982 ngisebenza lesiphoyisa kanti ngasebenzela ke i-uniform branch emva kwe-uniform branch ngaya kwi-crime intelligence kwalandela-ke i-organized crime bese ngisebenzela-ke ama-hawks. Kanti ngangihlosile-ke ukuthi ngeke ngize ngicede iminyaka endlule emithathu ngikwi-branch ethize yomsebenzi. Kanti-ke kuyiqiniso yebo ukuthi kukhona-ke amakhosi engeke ngawenza khona ngaphakathi-ke esiphoyiseni ngingayanga kangako kuyisikhungo semfundo. Futhi bengiloko-ke ngenza-ke nama-refresher course ukuthi ngivuselele ngiqale ngenza i-course ethize emva kweminyaka ethize okanye emva kwesikhathi esithize ngihambe-ke ngiyovuselela ilokho ebengivamise ukukwenza.
Has any court, regional or high court, ever rejected your evidence in a particular case?
No, never, my lord.
And so, Sinawo Makangela, no court has rejected his evidence, but in this particular case, the state's fourth witness did not have the right equipment, so there was information he failed to show or to prove, and then he also referred to a particular Brigadier Gininda, having to come and then explain certain things. And so, what should we understand about that interaction?
Now, what you do, you read the charge. And already, as I said, remember the state has a test to meet in this case. The state is the reason why this court is convened for all these days. And the state has to prove its case beyond any reasonable doubt. The moment there is a doubt, that evidence will have to be rejected. There's always a procedure. Remember, if one comes into court to give evidence as an expert, there is a process that must be followed as an expert in the field. Should you not follow that, it is telling that that evidence cannot be taken as it was supposed to be taken under the circumstances. It's a given that for you to undertake a particular task, you have to do certain things. If you have not done certain things, then that evidence will have to be rejected by the court.
It would appear... please finish your thought.
No, I'm sorry. Now, if you find these concessions from the state, from the witness, then this evidence, of course, at the close of the proceedings, either the accused persons, if they go for Section 174, I do not know, or after they have testified, once they close their case, in argument, they will say the court must put a finger on this evidence, must not even look at it, because as we say, it has its own shortcomings. So the court has to take a clean evidence that has not been gainsaid, where proper processes have been followed to get some of the, when an expert has performed this function, to get the evidence.
Sure.
In the scene.
Just a two-in-one, finally. You mentioned Section 174. What does that mean? And then also, what was your observation in terms of the witness, the fourth state witness that is? At some point, he got really frustrated, and the way in which he addressed the defense counsel, was that a missed opportunity on the part of the judge to call this particular witness to order, or was his behavior acceptable?
No, it's not acceptable. Well, that's why I'm saying I'm happy that the judge has been directing these proceedings well. But my wish is that he continues to do that even with witnesses. The duty of a witness is to answer questions, not to ask. Once you come, you give testimony under evidence in chief. Under cross-examination, the person who's in charge of that process is the defense counsel. The defense counsel says, I will tell if I want you to explain. In my questions, I want you to say yes or no. There may be a desire, there may be a burning desire in that witness to give an explanation because it feels like maybe he may be misunderstood. But however, the person who directs the ship is the defense counsel. And as you say, some of the remarks for a witness to tell the counsel what to do and what not to do, it is not acceptable in the proceedings in our courts. And the judge had to put an end to that, just to say, look, this is how it goes. If there's anything, if me as a judge, I feel like I want to give you an opportunity. Alternatively, if a witness wants to explain himself in a particular point, he has to say that to the judge. As an appreciation that he has been told that these are the do's. Even though you said I must say yes or no, my lord, may I give an explanation for my point? so that the judge says yes. Remember, the judge is in charge of the proceedings, but defense counsel has been given an opportunity to be in charge of that particular period of the cross-examination, of which it is done as well in terms of the law. So the judge allowed that witness in a way, just to have the leeway of addressing the court, of addressing the defense counsel anyhow.
Thank you very much.
You spoke of Section 174? Well, Section 174 would be if really, as we have seen in the first two state witnesses in this case, they said completely contradicting versions. Now the accused person is expected to come and answer on an allegation. Well, if in their opinion, having been advised by their counsel that we don't even know what to answer here, then it means there is nothing. If we call you to come and testify, you'll be implicating yourselves. We'd rather just go and say, well, prima facie, that is on the face of this evidence. When you say on the face, even if you can take the accused person and close him somewhere and keep him somewhere, can the court convict the person? If the court is going to convict that person, it can convict him based on which evidence? Because there would have been a plethora of versions, of which there's one charge, of which the versions of the witnesses have to talk to each other, have to corroborate each other and contradict each other.
Thank you very much for your time this afternoon. Sinawo Makangela is a legal analyst.